Good morning. Thank you for joining us for this webinar, which will briefly examine the issue of compliance with right-to-work legislation in the wake of GDPR. As you'll be aware, GDPR took effect in May of this year. However, in the words of the head of the ICO, the 25th of May introduction of the legislation was not a hard cut-off point, but more a checkpoint on the road to compliance. Consequently, reviewing recruitment processes in the wake of GDPR will be an ongoing exercise for many organisations, and we would urge you to look in particular at the area of right to work. Now, just looking briefly at right to work legislation, it's been an obligation for businesses to undertake for 10 years now. And in that time, two clear patterns have emerged. Firstly, the process that must be followed has become more complex. And secondly, the penalties for non-compliance have significantly increased. Since 2016, we've seen a series of guides and publications released from the Home Office covering this area of legislation, all of which have been routinely updated and modified, which creates the first challenge for business and HR teams. And that is, how do you make sure that everyone is up to date with the latest legislation and guidance and ensure that it's cascaded and adopted by everybody that is involved in the front line of recruitment? What does the future hold? Well, there is no reason to expect any change in either the trend of increased pressure on employers to ensure an individual has a valid right to work, or the increased penalties for non-compliance. And Brexit certainly won't change this situation, and undoubtedly will bring several new revisions to Home Office guidance that organisations will need to prepare for. From a GDPR perspective, the rights of individuals and protection of their data is clearly paramount. Special category data is personal data which GDPR says is more sensitive, and so by default needs more protection. And by the very nature of right to work checks, this involves the capture of very sensitive data, everything from passports, birth certificates, images and photos of the individual, and so on. So if we look at GDPR in a little bit more detail, then as far as the legislation goes, you could be forgiven for thinking that there are no implications for the conducting of right to work checks. Article 6 of GDPR includes a provision for processing where there is a statutory obligation. But that is not the whole picture. Article 5 sets out 6 important principles relating to personal data that just cannot be ignored because you have a legal right to hold the data. The 6 principles relating to personal data are how you must process in a fair and transparent way, collect and only use the data for the legitimate purpose, limited to what is necessary, kept accurate and up to date, stored such that they are kept for no longer than is absolutely necessary, and the data is held in a secure way with an appropriate measure to protect against the loss of data. Aside from the considerable fines for a data breach under GDPR, which is 4% of global turnover, you certainly don't need me to elaborate on the equally damaging consequences of being in the headlines for the wrong reasons. However, what you may not be aware of is that the Home Office publishes a quarterly list of companies that have fallen foul of right to work legislation. Last year, the Home Office issued fines totaling almost £40 million to hundreds of UK businesses. In the vast majority of cases, this was not because they had set out to deliberately break the law, but because they had simply didn't have proper processes in place to ensure compliance. If we look at recruitment today, then in many sectors it's now fast-paced and conducted off-site in coffee shops as opposed to more formal office settings. So what are the danger areas from a GDPR and right to work compliance perspective, and how can they be avoided? What I'm going to do now is to briefly consider the 4 common problems that we at Rightcheck encounter. The first is a common mistake. With the need to get staff on the shop floor as quickly as possible, the temptation is to leave the right to work check until some time after the person has started. This is a fundamental breach of Home Office legislation and leaves the organisation badly exposed. Right to work checks must be performed prior to the commencement of employment, whilst the individual remains a candidate and not an employee. Without doing this, the organisation will not have what is termed a statutory excuse from prosecution. And if you're in any doubt as to what constitutes a statutory excuse and how to acquire one, then please don't hesitate to contact us. From a GDPR perspective, there is the question of candidate consent. Whilst not necessarily required, as there is a legal obligation for the employer to have access to the information, it is important to ensure that your right to work process does include a mechanism to show the candidate was fully informed in a clear, unambiguous way about the processing of their personal data and the legal basis for doing so. Secondly, the tendency can be to simply use whatever documents the candidate has to hand. That could be a driving license, a bank statement, and to simply copy them and send them off to HR. But remember, GDPR dictates that you must limit processing of documents to whatever is absolutely necessary. This means that all your staff involved in the front line of recruitment must follow a strict process to ensure that the right documents are checked, dependent on the nationality and the circumstances of the particular candidate. Thirdly, there are several ways that organisations can inadvertently fall foul of not following the right process. For example, a familiar one is to ask the candidate to bring to interview photocopies of their ID documents, seen as a quick, simple way to get the check done. However, once again, it's completely non-compliant. The recruiter must view, check, and correctly attest the original documents in the presence of the candidate in order to conduct a compliant check. And incidentally, the recruiter must be one of your staff. You are not at liberty to outsource these checks to a third party. From a GDPR perspective, having a trail of photocopies of sensitive data floating around is clearly not great. Furthermore, employers need to have a process that is prepared for subject data requests. This could be from an existing or a past employee. It's worth considering whether your HR systems are smart enough to retrieve the right data at the right time to cater for this situation. Finally, there is the issue of managing the check once it has been undertaken. Aside from the need to keep accurate records of any time-limited documents that may require a recheck, there is the GDPR issue of ensuring documents are only stored for the required duration and that they are stored securely. A filing cabinet at the back of the store with paper copies or a spreadsheet saved on an employee's computer hard drive is clearly risky and should be avoided. You also need to ensure for GDPR that you are keeping and storing for a duration that is absolutely necessary. From a right to work perspective, this means you need to show that you have a process in place where checks are safely stored and retained and then deleted 2 years after a person has left your employment. So what are the key messages coming out of this webinar? Firstly, compliance with right to work legislation is not straightforward, and we would urge you to review your current procedures and to comply with this critical area of employment legislation, especially in light of GDPR. Secondly, there are significant penalties and fines, but it's the risk of reputational damage that can be the hardest to recover from. And thirdly, compliance in this area doesn't have to be a headache. At Rightcheck, we are working with some great organisations that not only improve compliance with Rightcheck, they have also saved time, admin, and cost by operating a more efficient process. Just a little about Rightcheck, if I may. Rightcheck is an app-based solution. It's available on Apple, Android, and Windows platforms. It simplifies the process by intuitively guiding the user through a process to always conduct a compliant check. The underlying logic is automatically updated when legislation changes, so you don't need to worry about monitoring and cascading this vital information. There is also an integrated management portal with Rightcheck where you can control access, who has access to the system, review checks, and gain a complete audit trail of how the personal data has been processed. And Rightcheck also looks after the archiving and deletion in a situation of ex-employees. So finally, I'd like to thank you again for joining us for this morning. If this webinar has prompted concerns, issues, or you have any unanswered questions or queries, then we will be delighted to assist you. You can contact us via email at info@rightcheck.io or do call us on 024 76 15 8830. Once again, thank you very much for joining us this morning. I do hope this has been useful to you, and do make contact if we can help you in any way. Thank you.